You've gutted the Bureau of Institutional Knowledge and Expertise. You fired or pushed out seasoned FBI officials, many with more than 20 years of experience, who were working on cases that were critical. You've been purging thousands of serious law enforcement officials who spent their careers keeping us safe, only to lower hiring standards in order to find anyone to replace them. And shockingly, you admitted in this hearing to Senator Coons that it would take 14 years to fill the vacancies at your agency. Many are the result of your purge.
Kash Patel is in serious legal trouble right now, and what's been exposed could send him to jail. FBI director is facing immediate arrest threat from federal judge over Epstein files. Judge gave him hard deadline to produce documents or face criminal contempt with federal marshals ready to take him into custody. But that's not even worst part. Fired FBI agents are suing Patel with lawsuits that quote his own alleged admissions of knowingly breaking law. According to complaints, Patel admitted he knew firing agents without cause would violate FBI rules and federal law, admitted he could be sued, but said his job depended on removing agents who investigated Trump, so he did it anyway. That's knowing violation of law. That's deliberate law-breaking to serve Trump's interests, and now it's all documented in federal court filings. This is lethal evidence that could destroy Patel legally, could send him to prison, could prove entire FBI purge was criminal conspiracy. And Patel has nowhere to hide. If you want to stay ahead of the headlines, please subscribe, because you might think you are but aren't. Your subscription actually matters here. That's why we built John Brown Show, to bring you real stories, real context. All right, let's get into why Patel's legal exposure is so serious, because he's facing threats from multiple directions simultaneously. First is contempt proceeding over Epstein files. Judge Richard Berman reportedly gave Patel deadline to turn over all ordered documents or face arrest warrant for criminal contempt. Federal marshals were on standby. This wasn't theoretical future exposure. This was present tense judicial ultimatum with hard deadline days away. Share this video with everyone you know, because judge's rejection of Patel's excuses was brutal. Patel reportedly argued classification, privilege, ongoing investigations as reasons for withholding documents. Judge rejected each argument, cited prior rulings that those claims had already been litigated and lost, told Patel he couldn't re-argue claims that already failed, that his continued assertions looked like delay tactic, not legitimate legal position, and judge said something devastating, told Patel that FBI director is not above law, that position confrontation as test of whether powerful officials can simply refuse judicial commands. Patel holds one of most sensitive positions in government. His resistance to court-ordered document production raises question about whether officials with enough power can defy courts. Judge's statement rejected that possibility explicitly. Think about what that means. Epstein context makes this politically explosive. Jeffrey Epstein's connections to powerful figures have generated intense public interest in what records might reveal. FBI has possession of documents from investigations into Epstein's activities. Courts ordered production of certain records. Patel's resistance to producing those records creates appearance he's protecting information that could damage powerful interests. Make sure you're subscribed to John Brown Show, because what's being withheld matters enormously. Court orders requiring document production typically specify categories of relevant materials. Patel's resistance suggests ordered documents contain information he or Trump administration prefers to keep private. Whether that reflects legitimate classification concerns or desire to suppress damaging information isn't clear from outside, but resistance itself creates adverse inference that there's something explosive being hidden, and consequences were immediate and real. Judge reportedly had federal marshals on standby to execute arrest warrant if Patel missed deadline. That's not symbolic threat. That's operational preparation to take FBI director into custody. Specificity of deadline, date, and time and consequence indicated judge who wanted no ambiguity about expectations. Patel's options had narrowed to compliance or arrest. Second track of exposure is lawsuits from fired FBI agents. Multiple suits filed in federal court alleging Patel fired senior agents for politically motivated reasons, violating their constitutional rights. Plaintiffs include agents who worked on investigations involving Trump and agents who kneeled during George Floyd protests. Each category involves different protected conduct allegedly punished through termination. First Amendment claims concerning protest participation assert that kneeling during racial justice demonstrations was protected expression. Government employees retain First Amendment rights, including expression on matters of public concern. If agents were fired for expressing views through protest participation, that potentially violates constitutional protection. Terminations would be retaliation for protected speech, not legitimate personnel action. Claims concerning agents who worked on Trump investigations involve due process analysis. Employees have rights constraining arbitrary termination. If agents were fired specifically because they investigated president, that's pretextual termination violating due process. Firings would be punishment for doing their jobs rather than performance-based decisions, and that's exactly what lawsuits allege happened. But here's where evidence becomes lethal. Federal complaints and congressional filings quote Patel, acknowledging that firing agents without cause would be in direct violation of FBI rules and federal law. Quote him acknowledging he knew he could be sued. Quote him saying his job depended on removing agents who worked on cases against president. If these quoted statements are accurate, they establish knowing violation of law. Think about significance of that. Patel allegedly understood his conduct was unlawful before engaging in it. He proceeded anyway because he believed Trump expected it. This transforms conduct from overzealous execution or honest mistake into deliberate lawbreaking. These aren't allegations from plaintiffs claiming what they think Patel knew. These are statements attributed to Patel himself acknowledging he knew firing agents was illegal but did it anyway to keep his job. Quotes would be devastating evidence in civil suits if authenticated through testimony or documentation, because they prove mens rea, guilty mind. Show Patel had knowledge his actions violated law. Show he acted anyway to serve Trump's interests. That's criminal intent in civil context. That's basis for punitive damages. That's evidence that could be used in criminal prosecution if DOJ ever decides to charge him. Senator Cory Booker laid out consequences of Patel's actions in hearing. Said Patel has made country weaker and less safe, that we're more vulnerable to major event, that Patel gutted Bureau of Institutional Knowledge and Expertise, fired or pushed out seasoned FBI officials, many with more than 20 years experience working on critical cases, been purging thousands of serious law enforcement officials who spent careers keeping us safe. And Patel admitted in hearing to Senator Coons that it would take 14 years to fill vacancies at agency. Many vacancies are a result of his purge. Think about that. FBI director admits he's created staffing crisis so severe it would take decade and a half to recover. That's not reform. That's destruction of institution. That's gutting nation's premier law enforcement agency for political purposes. Pattern of behavior and testimony adds additional exposure. Coverage describes Patel repeatedly invoking Fifth Amendment and stalling under oath in various proceedings. Judge reportedly characterized his behavior as abusive, warned that continued refusal to answer or comply could result in contempt and jail. That indicates judicial patience exhausting, shows judge viewing Patel's tactics as obstruction, not legitimate assertion of rights. When Patel repeatedly invokes Fifth, right against self-incrimination, that indicates he believes truthful testimony could incriminate him. If he had nothing to hide, if his conduct was lawful, he could answer questions. But he invokes Fifth because answering honestly would provide evidence of crimes. That's what Fifth Amendment invocation means. It's admission that truth would be incriminating. Connection to Trump creates broader implications about how administration uses law enforcement. If Patel fired agents because Trump wanted investigators purged, that's president using FBI director to retaliate against people who investigated him. Pattern raises rule of law concerns about weaponizing law enforcement against perceived enemies. Patel becomes instrument of presidential retaliation, and lawsuits become accountability mechanism for that retaliation. Think about what that means. Now let me break down why Patel's exposure is so much worse than typical political appointee facing lawsuits. Because he has multiple independent legal tracks creating compound jeopardy operating simultaneously. Contempt proceedings with immediate arrest threat, plus civil lawsuits with documented admissions of knowing lawbreaking, plus potential criminal exposure from both. Contempt threat involves potential immediate arrest. Most acute exposure. Federal judge told Patel produce documents by specific date and time or face arrest warrant. Marshals on standby indicated operational preparation, not rhetorical posturing. Deadline was days away, not months. Consequence was custody, not fines. This represents real-time legal jeopardy of most direct kind. If Patel missed deadline, if he didn't produce documents, arrest warrant would issue. Federal marshals would execute. He'd be taken into custody on criminal contempt. That's not civil contempt where you stay in jail until you comply. That's criminal contempt where you're punished for defying court. Could mean jail time even if he eventually produces documents. Could mean criminal record. Could mean end of career. Civil lawsuits operate on longer timeline but create different kind of jeopardy. Constitutional violations and personnel decisions can produce significant damages. Wrongful termination suits with First Amendment and due process claims carry potential for compensatory and punitive damages. If juries believe Patel knowingly violated agents' rights, awards could be substantial, and he'd be personally liable because qualified immunity doesn't protect officials who knowingly violate clearly established rights. Share this with everyone because alleged admissions are game changer for those lawsuits. Normally, plaintiffs have to prove defendant knew conduct was unlawful. That's hard, requires circumstantial evidence and inferences. But if Patel admitted he knew firing agents without cause violated law, plaintiffs don't have to prove knowledge. They just have to authenticate the admission. And if admission came in congressional testimony or documented conversations, authentication is straightforward. That makes liability almost certain if admissions are proven, because Patel can't claim he didn't know conduct was unlawful when his own words show he did know. Can't claim he acted in good faith when he admitted knowing it violated rules. Can't claim qualified immunity when he knowingly violated clearly established rights. His own admissions destroy every defense he might raise. And punitive damages become likely with knowing violations. Juries award punitives to punish deliberate wrongdoing and deter similar conduct. When defendant admits he knew conduct was illegal, but did it anyway to keep his job serving president, that's exactly kind of deliberate wrongdoing punitives are designed to punish. Awards could be massive, could bankrupt Patel personally. Pattern of Fifth Amendment invocations suggests criminal exposure beyond civil liability. Fifth, protects against compelled self-incrimination in criminal matters. When someone invokes Fifth in civil or congressional proceeding, they're saying truthful answer would provide evidence usable in criminal prosecution. Patel invoking Fifth repeatedly suggests he believes he's committed crimes and that testifying honestly would prove it. What crimes could Patel face? Obstruction of justice for defying court orders and withholding Epstein documents, deprivation of rights under color of law for firing agents in violation of their constitutional rights, conspiracy if he coordinated with Trump or others to purge FBI of investigators. Each carries serious prison time if prosecuted and proven. Think about what that means. Judge characterizing Patel's testimonial behavior as abusive indicates something beyond proper assertion of rights. Legitimate Fifth Amendment invocation is constitutional right that should be respected. But pattern of invocation combined with stalling and refusal to comply with court orders creates appearance of someone using procedure to avoid accountability rather than protecting legitimate privilege. Epstein file dimension adds political volatility that increases pressure on Patel. Whatever those documents contain, resistance to producing them generates maximum public interest and suspicion. Everyone wants to know what's in files about Epstein's connections to powerful figures. Patel's refusal to produce despite court order makes people assume he's protecting explosive information. That increases political pressure for accountability. And it connects to broader Trump administration pattern of covering up Epstein materials. Congress demanded files. Administration refused. Courts ordered production. Administration delays. All suggesting there's something in those records that administration desperately wants to keep hidden. Patel is face of that cover-up, and that makes his legal jeopardy more than personal problem, makes it political crisis. For Trump's inner circle, Patel's exposure illustrates risks of implementing presidential preferences that conflict with law. Agents Patel allegedly fired didn't do anything wrong. They worked on legitimate investigations or participated in protected protest. Patel allegedly fired them anyway because Trump wanted them gone. Now Patel faces personal liability while Trump remains protected by presidential immunity. Pattern shows how loyalists absorb legal consequences for implementing Trump's preferences. Trump directs, Patel implements. Patel faces consequences, Trump doesn't. That's asymmetry built into system. President has immunity, subordinates don't. So when president orders illegal actions, people who carry them out face prosecution, while president remains protected. Bottom line is this: Kash Patel faces immediate arrest threat from federal judge over Epstein files. Judge gave final deadline to produce all ordered documents or face criminal contempt warrant. Federal marshals on standby. Judge rejected all Patel's privilege claims. Said FBI director not above law. Resistance to producing documents creates appearance of protecting explosive information about Epstein's powerful connections. Simultaneously, Patel faces lawsuits from fired FBI agents alleging constitutional violations and politically motivated terminations. Complaints quote Patel's alleged admissions acknowledging firing agents without cause would violate FBI rules and federal law, acknowledging he could be sued, saying his job depended on removing agents who worked on Trump cases. If authenticated, these admissions prove knowing violation of law. Senator Booker said Patel gutted FBI of institutional knowledge and expertise, fired thousands of experienced agents, created vacancies that would take 14 years to fill according to Patel's own admission, made country weaker and more vulnerable, all to serve Trump's desire to purge investigators who worked on cases against him. Patel repeatedly invoking Fifth Amendment suggests he believes truthful testimony would incriminate him. Judge characterizing his behavior as abusive indicates obstruction, not legitimate privilege assertion. Pattern of delay and defiance exhausting judicial patience, making contempt and arrest increasingly likely. Multiple independent legal tracks create compound jeopardy, immediate arrest threat over contempt, civil liability for constitutional violations, potential criminal exposure for obstruction and deprivation of rights, alleged admissions destroying defenses and making liability almost certain if proven, political pressure from Epstein cover-up increasing scrutiny, all converging to make Patel one of most legally vulnerable figures in Trump administration. This is lethal evidence. Own admissions proving knowing lawbreaking, court orders being defied, constitutional rights being violated, all documented, all creating exposure that could send Patel to prison, could bankrupt him through damages, could destroy his career and legacy, and he did it all to serve Trump. To keep job by purging investigators, now facing consequences while Trump remains protected. This story continues. Stay tuned.